Avery Thorne was, professionally, a master of corporate architecture. As a specialist in corporate governance and parliamentary procedure for national nonprofits, her expertise lay not in drafting new law, but in the unblinking enforcement of the law already on the books, specifically, the fatal, often overlooked technicalities buried deep within organizing documents. Her home in the upscale, meticulously manicured community of the Grand Oaks offered little respite from her professional scrutiny. Over the last decade, under the zealous leadership of President Victor Sloan, the community had devolved into a bureaucratic nightmare of micromanagement. The HOA board, fueled by a desire for total aesthetic control, had passed a relentless series of increasingly petty, unworkable, and contradictory new bylaws. These regulations covered every imaginable aspect of homeownership. Mandatory. Specific colors for trash cans only hunter green and only visible on Tuesday between 6 a.m. and 6 p.m. A new, prohibitively expensive fine schedule for minor lawn height variations. A ban on planting any non-native species without a 12-page application. And an absurd rule mandating that all holiday lights, regardless of the holiday, must be removed within 72 hours of the event's end, with a $50 daily penalty thereafter. The cumulative effect was suffocating. Sloan and the board had managed to turn a comfortable neighborhood into a legislative prison, driven by the perceived authority of their endless rulebook. Avery suffered through several citations, once for leaving a hose reel visible past dusk, and another for the unauthorized shade of blue on a bird feeder, but her frustration quickly matured into cold, analytical resolve. She realized that trying to fight the individual bylaws was pointless. She needed to challenge the legal authority that gave the board the power to create them in the first place. This was a classic case of corporate overreach, and Avery instinctively knew that if you want to fell a giant, you attack the ankle, not the head. Her investigation began with the root of authority, the original organizing documents of the Grand Oaks HOA. She secured certified copies of the Articles of Incorporation, the Declaration of Covenants, Conditions and Restrictions CC&Rs, and the founding bylaws, all filed when the community was established in 1988. Most residents and, crucially, the current HOA board and its lawyers assumed these documents were boilerplate and interchangeable. Avery knew better. She began meticulously cross-referencing the bylaws amendment procedures with the state's corporate law statutes, in effect at the time of the community's founding. The discovery was not dramatic but legally lethal. It was found deep within Article 10, Section 3 of the original 1988 CC&Rs, titled Amendment Procedure. The clause, written under an older, stricter section of the state's Nonprofit Corporation Act, stated clearly and unequivocally that the CC&Rs and all subsequent bylaws derived from them may be amended only by the affirmative vote of not less than two-thirds of the membership. The HOA consisted of exactly 500 residential units, each holding one vote. The wording two-thirds of the membership therefore meant that any amendment required a minimum of 334 affirmative votes, 66.7% of 500. Avery knew, with chilling certainty, that this threshold had never once been met. The typical attendance at HOA annual meetings hovered around 70 to 80 residents, barely reaching quorum. The HOA board, relying on the simplified rules common to many other communities, had been incorrectly interpreting that Clause 2 mean two-thirds of the votes cast by members present at a meeting where a quorum is achieved. They were voting in major amendments with 40 or 50 votes. Every single bylaw amendment passed since the first flawed vote in the mid-2000s was fundamentally invalid. Avery did not warn the HOA. She did not appeal the latest fine. She compiled her evidence, the 1988 CC&Rs, the relevant section of the Historical State Corporate Code, and the HOA's meeting minutes for the last 2 decades, clearly showing votes of 55 in favor, a majority of attendees, but a catastrophic failure of the 334 vote requirement. She then engaged a specialized real estate litigation attorney and filed a declaratory judgment action in the state court. This type of lawsuit doesn't seek damages, but simply asks the court to declare the legal rights and status of a matter in this case, the legal validity of the last 15 years of HOA rulemaking. The petition was surgically precise, targeting the core corporate structure. It argued that because the initial 2005 vote to adopt the first major amendment failed to achieve the mandatory 334 vote threshold of the total membership, that amendment was void ab initio from the beginning. Furthermore, because every subsequent bylaw and rule relied upon the foundational authority established in that first faulty amendment, every single rule, regulation, and fine passed since 2005 was legally null and void. When the summons arrived, Victor Sloan and the HOA General Counsel were initially dismissive. Procedural error, Sloan scoffed, planning to argue custom and practice and implied ratification by the membership. However, the judge, a stickler for corporate fiduciary law, quickly seized on the point. The state law was absolute. Corporate governing documents, especially those concerning the amendment of property rights, must be followed to the letter. Custom and practice cannot supersede a mandatory voting threshold explicitly written into the founding charter. The court required a specific legal demonstration. Could the HOA produce any evidence that 334 residents had ever voted to approve any of the major amendments? The answer was a definitive, humiliating no. The ruling was immediate, final, and devastating. The judge declared that the HOA's interpretation of the 2/3 rule was fundamentally incorrect and violated the Nonprofit Corporation Act in place when the documents were filed. The court ruled that every single amendment, bylaw, architectural guideline change, fine schedule, and rule passed since January 1, 2005 was legally void, unenforceable, and without effect. The Grand Oaks HOA was instantly reverted to its original 1988 charter, a bare-bones, simple document that dictated little more than the maintenance of the common roads and the collection of minimal fees for shared amenities. All of Victor Sloan's beloved petty rules, the trash can colors, the lawn ornament restrictions, the fine schedules, and the ban on non-native plants, vanished in a single judicial stroke. The financial and political implosion was total. The court, citing the HOA's reckless disregard for its own foundational documents, ordered the HOA to immediately refund every single fine collected under the now voided rules of figure, estimated at over $70,000, and, critically, ordered them to cover all of Avery Thorne's extensive legal fees, which had reached $22,000. This instant, massive financial drain forced Victor Sloan and the board to initiate a panic-stricken special assessment to cover the court-mandated refunds and legal costs. The community, now utterly chaotic, without any functional rules and facing a massive financial penalty, turned on the board. Victor Sloan resigned immediately amid community-wide ridicule. The cost of their 15-year failure to correctly count the membership vote had bankrupted their reserves and eliminated their authority. Avery Thorne had not just defeated a handful of bad rules. She had executed a corporate law checkmate, proving that the foundation of authority, if improperly laid, can be used by an expert to topple the entire structure. The Grand Oaks, suddenly free of its bureaucratic chokehold, celebrated by leaving mismatched trash cans out on the curb all week long.